For admission. For admission, item number 1.
At the outset, Your Lordship. May it please, Your Lordship. My Lords. At the outset, Your Lordship, with regards to the writ appeals that was heard yesterday, as allowed by Your Lordships, I may be allowed to place my judgments.
Oh yeah, that submission.
Yes, Your Lordship. Just only just some 4 or 5 points, Your Lordship. Very short. Just 5 pages, Your Lordship. Just confined it to that point only.
Now tell me, if we don't pass any order,
My Lord.
we say we don't touch 48 AB,
My Lord.
B, then what happens?
Then I will still, the
What will happen to you?
appeal would still
Because
be
if you
available
see
to me.
the judgment
My Lord.
of the learned single judge.
My Lord.
There is one paragraph wherein it says that you should have gone for execution.
I did, Your Lordship, rightly or wrongly. I've placed it on record. Yesterday, I could not get it on time. But what I did was, rightly or wrongly, I had filed for execution. I had filed execution, but that was dismissed by the additional district judge for lack of jurisdiction. Again, I approached this honorable court, a single bench, by filing CRP, which was eventually allowed.
But CRP only allowed only for the purpose that you were not heard.
No, also because the additional district judge did not exercise its jurisdiction, which otherwise it has. Because as per the definition of court under LA Act, court is defined as the principal court of original jurisdiction. As per the Mizoram Civil Courts Act of 2007, the original principal court of original jurisdiction is the district judge. That was my humble submission before the single bench, and that was allowed.
Understood, but the fact that an award which is normally passed, it's only an order passed by the district collector.
Right.
Can you put to execution?
It
It is not by the district judge.
Now I have realized that issue that Your Lordship has pointed out correctly, and also what I've placed in my points of consideration that which I've just submitted is that the full bench of the Allahabad High Court, Andhra Pradesh High Court, has held that under exceptional circumstances, even under petition filed under 226, the basic principles of the CPC can be applied for the essential administration of justice.
Understood. Everything is understood.
So, by virtue of Order 41, Rule 33, even if a party has not filed any appeal for the purpose of doing complete justice, it can be interfered and relief can be granted to the respondents. And also, Your Lordship, even if it is modified, that 48B is modified, the directions of the single judge would not be changed in a way that only the manner will be changed, but not the direction, because the direction was that it was that I should go for execution. Ultimately, the direction was that please pay the compensation as per the award. Ultimately, that is the purpose of the direction of the single bench. So that in itself will not change. The manner will change, but the nature of the direction of the single bench will not change, in my humble opinion, Your Worship.
But can, by way of an order, you can confer a jurisdiction on an authority which does not have an jurisdiction?
No, my lord. My humble submission or my humble opinion in that respect is that instead of directing the private respondents petitioners to go for execution, the original prayer of the writ petitioners can be granted by directly with a direction to the state to make the necessary payment, be it the state or NIPCO, whichever is the concerned authority. Because ultimately that was the direction of the single bench. It's only the manner that will change.
But you were never agreed with that direction.
My lord?
You were never agreed
Because
with
I
the
was
direction.
under the wrong impression and
Just for example,
for
if the appeals were withdrawn
my lord.
and it remained as it is, what would have happened? We are taking up the appeal, it's a different aspect of the matter because of the fact that the Supreme Court had restored it. Otherwise, the appeal was withdrawn.
Correct.
You were satisfied then also.
No, my lord, I had filed the execution.
Understood. But can you confer, therefore, without touching that, whether your execution is maintainable or not, later on, how do you take care of that? Yes, you may have filed, but tomorrow, at the end of the day, once you file the execution,
In such scenario, Your Lordship, ultimately I would be constrained to file the appeal and challenge the 48B to the extent that Your Lordship has mentioned, no doubt. But Your Lordship, we were under the wrong impression regarding that, and on our side, bona fidely, we
You
had
do one
taken the
thing.
steps,
do one thing. Yesterday, I passed the judgment. We have passed the judgment.
my lords.
In the case of Mr. S. Dotto, you were not there because we were going around 5 o'clock. Have a look at the judgment.
I shall, Your Lordship.
From there, if you can do something, think about it, what can be done.
Of
I
course,
think
Your Lordship.
for this court to suggest would not be proper, but this is the indication I'm giving it to you. How you are going to, something can be done to that effect.
My lord.
Because the argument which was made therein was that the writ court could not have been an executing court.
Understood.
And that in that respect, they have relied upon a judgment in the case of Jagdev Sate or something.
My lord.
But in that case, the Supreme Court made these observations in the context of a challenge being made to the award, land acquisition award under Section 34 of the Arbitration and Conciliation Act, and observe that when there is an award which is pending before the appropriate court, and there is a challenge to the award which is pending, the writ court could not have. In that context, we say that that judgment would not be applicable.
Correct.
And taking into account the judgment in Kolkata Municipal Corporation,
Right.
which is, I think, 2024 SCC Online 868, we observe that it is a right under 300A to get it. And as such, the single judge was justified in passing the issuance of that mandamus. So this was the directions which observations which we made.
My lord.
On that basis, I think what to do.
In fact, Your Lordship, the present petitioners in these writ appeals, in fact, as would suggest from the award or the quantum of the award that has been given, they're all in the range of 30,000, 40,000. Of course, that value has drastically gone down as on today. So this goes on to show that these are all very, very poor people.
Understood, everything is understood. But the fact that there was a mistake, because there was one paragraph number 47 in the 46 of the impugned judgment, wherein the learned single judge categorically observed that you can't file a writ petition. That means the writ petition was dismissed. It's a different thing that the state is filing appeals. Your writ petition, in fact, what did you ask for? A mandamus directing these authorities to make the payment.
Correct.
But when the single judge has already held that you could not have filed a writ petition, how do you take care of that situation without filing an appeal?
Understood, Your Lordship.
Think about it, what is to be done. But otherwise, we are to help you out, but we can't help you out. Our hands are tied. Let's see.
Yes, Your Lordship.
We propose to deliver the judgment tomorrow. Let's see where it is.
Very well, my lord. Now, in this PIL, Your Lordship, this item number 1. This is the item
We
which,
do one thing, this PIL, we have it in before another bench, taking into account that this court is not much aware of the
right, it's a little bit
various area.
localized, and I mean the issues.
Let it be listed next week.
Not a problem at all, Your Lordship.
List this matter next week at the request of the council for hearing on behalf of.
Item number 2.
Yes, what is this?
Item number 3 and 4, my lord, arising out of same judgment.
What is this? What you are challenging?
My lord, I am challenging the judgment, my lord, is
Huh? Is an IA?
IA is for stay, my lord.
IA for stay.
Stay, my
Item
lord.
number 2 and 3.
My lord, item number, my lord, my item is
2 and 4
2 and 4, my lord. 4,
are same.
4 is already admitted, my lord, and the stay is
What
there,
is
my lord.
2? What are you challenging?
Yes, my lord.
They're not the same judgments, Your Lordship.
Yes, I'm pointing out. Judgment is, my lord, page 144, my lord, 149. 149. The relevant portion, my lord, is, my lord, on the basis of the judgment of the apex court, my lord, the rental compensation was, my lord, direction to pay the rental compensation, my lord. It starts from, my lord, page 50, 54, 55, 55, para 9. Here case,
What is wrong with the order?
My lord, here, my lord, this rental compensation was made from according to them, my lord, 1996, they have LSC, my lord. LSC was from 1996, and my lord, thereafter, my lord, before acquiring land, my lord, they have never claimed the rental compensation, my lord. After 26 years, my lord, after, my lord, there is a direction in other case, my lord, other petition on 2000, my lord, because 1996, the army was occupying the land from 1996, my lord. Yeah, to
So
continuous.
do you have a right to occupy?
No, my
any
lord, no, my lord, no, no. We paid the rental compensation at that time, my lord. At that time, rental compensation was less, my lord. Thereafter, in 2000, the owner of the land came approached this honorable court. There is judgment also here, my lord. And this honorable court, there is direction, there is observation to acquire the land also. They pay the compensation also, my lord. That is there, my lord. Their contempt was filed, my lord. Thereafter, my lord, there is notification, my lord, as per the procedure, my lord. And in their preliminary inquiry, my lord. In preliminary inquiry also, my lord, the name of the petition were not there, my lord. And thereafter, my lord, they file objection, my lord, under the new act, my lord. And their name inserted, my lord, according to their land also acquired by the concerned district collector, my lord. In 2019, my lord, this land, my lord, according to them, my lord, their LSC in 1996, my lord. And from the record speaks, my lord, the original, the owner, my lord, at that time, they are LSC 1996, but this is my friend's LSC is 2003, 2005, like this, my lord. It is there, my lord. So after this, when they got compensation, my lord, after they filed the petition in 2019, claiming that they were forcefully dispossessed, and so they are entitled the rental compensation. Here the judgment, this mentioning the judgment, my lord, the Arla Joiner Insurance 2004, my lord. It is, my lord, page, my lord.
2004 4 SCG 79.
Yes, my lord. Here, on the basis of the judgment, this honorable court, single bench directed to pay the compensation, my lord. In case where the landlord is dispossessed prior to issuance of preliminary notification under section 4.1 of the Act, government merely takes possession of land, but the title they continue to vest with the landowner. It is fully open to landowner to recover the possession of land by taking appropriate legal proceeding, and he is therefore entitled to get rent and damage for use and occupation where possession is taken prior to issuance of preliminary notification. Our opinion, it will be just and equitable to the collector may determine the rental damage for use of property to which.
Let us see your affidavit.
My affidavit, my lord, this not there's two affidavit filed by state government also, my lord.
No, your affidavit.
Yes,
What you filed it before the writ court.
Yes, my lord.
Where is that affidavit?
I'm coming.
Let us see that affidavit. What is your stand?
My affidavit, my lord, is 146. $74, my affidavit, my lord.
Huh?
Page 74, my affidavit.
74.
Page 74, my lord. Page 75, my lord. Paragraph 7, my lord. The petition denied the answering deponent state the demand of rental compensation of the land at the helipad area of Trampe first was received from office of the DC Isle, in which number of claimant was 65 claimant for the period of 86 to 97. In which the name of the petitioner were not shown, which indicated the land owner was not under the land of the petitioner was not under occupation of the army. Copy of the second demand of rental compensation of land helipad area was received so which number of the claimant was 45 claimant for the period from 1/98 to 2005, in which the name of the petitioner were not shown, which indicated land the petitioner was not under the occupation The third demand, rental compensation of helipad, so and so, so and so. The claimant was 45 claimant for a period of 2006-2007, which name of the petitioner was not shown. So, my lord, all the time, 3 times we paid rental compensation, then their name was not there, my lord. Only when they as per the order of the honorable court, when there is issue.
Yes, government. The private respondent. Yes, tell me. You are the petitioner.
Yes, Your Lordship.
You are claiming rental compensation from when?
From from the date of issuance of my settlement certificate.
Huh?
From the date of issuance of my land settlement certificate. The reason being is
No, it can't be from the date of issuance of your land holding certificate. It has to be from the date they have taken possession.
no, possession was always in their hands since 1966, Your Lordship. This is 66.
66.
That is the period of insurgency.
Okay.
This is clearly reflected at page 44. That is part of the award. In the award itself, it is clearly mentioned that structure valuation is there.
What is the name of the petition?
Page 44. That is part of the award.
Your names were not there.
My name is there. In fact, I've already been paid the compensation for acquisition also.
But the compensation
For acquisition, they have already paid in 2021.
And they say that all these awards which were being made or these rental compensation,
My lord.
this is by you, page 72.
My lord.
So you got your LSC only in the year 1996.
Some of them 96, some of them
No,
94.
we are only concerned with 3 petitioners. No?
Correct.
So you got the year only in the year 1996.
The oldest one is
We are
94.
concerned with Remisa Nengte, these are 96. Then Mr. Landungea, that is 2003, and the other is of 1994.
My lord.
Now, how did you get these LSEs?
I had purchased it, Your Lordship.
You purchased this land.
Yes. So the previous owner's name is also reflected in my LSEs.
So the previous owner's name were there
There. In the
rental compensation thing.
no rental compensation was ever paid to me.
No, because they are saying something in the affidavit to the effect, page 74, if you see. Affidavit. Kindly come to paragraph 7, page 75. There are office of the DC Aizol in which the number of claimants was 65 for the period from 1686 to Iman 87.
Yes.
Now this is the document which they are enclosing, Annexure 1 to that. Now is your owner, is your predecessor there in this list?
In that list, no, it was not there.
Huh?
It's not there, my lord.
It's not here.
It's
Even
not here.
not your name.
Not the previous
From whom
owner.
you purchased,
Yes,
your name is not there.
not there. But what happened is that, Your Lordship, even from the award itself, what can be seen is that the actual number of landowners increased.
So in all Annexure 1, 2, and 3, your name, your or
I have never been paid the rental compensation
your or
prior
your
to acquisition.
predecessor's name was never there.
Never there.
So the question is, if your name or your predecessor's names are not there, are these not disputed questions of facts?
No, my lord. In my humble opinion, the very fact that at page 44, the area has been occupied by the security forces since 1966, therefore no structure or tree, crops or so and so. And also the fact that my name is there in the lands that was actually acquired and for which I have already been paid compensation.
Well, very well. So you are entitled to the rental compensation from a particular period of time.
Correct.
So are you not required to show the proof that your land was also occupied by them? how can you approach and file a writ petition?
Your Lordship, if I may be given some time, maybe till tomorrow or day after, I will come back with that because
Why? No,
since-
no. All your tomorrow business does not happen here. Yesterday also you said tomorrow. Tomorrow does not happen. You therefore have to answer today as to why your name, why you should not go to the civil court. You show that. Prove
yes,
it.
I will show that, Your Lordship.
No, you prove it before the civil court. That
No,
look, here
the
this has
reason
happened.
the reason being is that in
Because
the,
your name, you see, they say we are in occupation of this land from such and such period.
My lord,
The DC Isol from time to time has submitted claims as regards the rental compensation. You yourself admit that your predecessor from whom you have purchased, their names are not included in this. You say that you have purchased in the year 1996 and got in the LSCs in the year 1996, 94 and 2033. These are the things which you have gone.
Correct.
Now you have got, say that you have got the the acquisition expenses. Very well, fantastic. You have now got the money. It is very nice. But the fact that all earlier period you are entitled to it is a question of proof.
the reason being is that, Your Lordship, in the award itself, it is clearly written that the area has not increased. The area occupied by the security forces has
May be a
remained
fact.
unchanged.
No, it is a fact. You see, there are two aspects of the matter. The award which has been passed subsequently, thereby acquiring the land which is being acquired now, is on the basis of a notification issued under Section 11
Right,
of the 2013 Act.
correct.
Now, when this notification is issued, it is only in respect to those lands. It may be more or less than what was occupied by them. But therefore, can it be said that because of the fact that you have been paid the awarded compensation in respect to the acquisition would also mean that your land was also occupied by them?
No, the reason why I'm saying this, Your Lordship, in the award itself, due as part in the process of acquiring the lands of, including the lands of the petitioners, verification was conducted. In the award itself, it is stated that the area occupied by the security forces has remained unchanged. Now, when it has remained unchanged since the period of from the initial occupation, and the fact that my name is there in the lands acquired eventually, will go on to show that my land was in fact under occupation. And how can they dispute that when they have not, they participated in the acquisition proceedings, in the verification proceedings, they have not said that this particular land or that particular land is not under occupation.
Let us see the award where it is said.
And in preliminary inquiry, their name was not there. Preliminary inquiry was there, as per notification, their name
Let
was.
us see the award where it says.
What is my lord, PS, my lord. PS, my lord, 40, my lord. PS 14. PS, my lord, 58, my lord. And next 10.
Yes. Where?
If your lordship, if your lordship can kindly indulge with me, if this matter may be passed over for the time being, and let it be taken up with this item number 4 in the meantime, your lordship.
Four we are taking now only.
I'll just go through it properly because the copy that has been furnished to me is very, very
My lord,
black. I mean, like, it's not legible.
My lord, it was
So,
my lord, preliminary.
Let it
inquiry. There is- their
be
name was
taken up
not
with
there, my
this
lord.
item 4, since my letter friend has said that these are
And
two
therefore,
similar
my lord, they
items.
file objection, my lord, somehow they enter their name, my lord.
Just for the time
And
being, Your
fact is
Lordship.
that another thing I want to point out, my lord, their LSC was, my lord, so far their LSC was concerned, my lord, it was transfer LSC, my lord, transfer LSC. Transfer LSC, my lord, page 31, my lord, page 31, page 32, my lord. Page 32, my lord, see, it is transferred, my lord, on the left side, my lord. It is transferred to them, my lord. They are claiming 1996, my lord, that it is transferred, my lord, on 2005, my lord.
No, this is a certificate of page 32.
32, my lord, this is
This is
certificate
LSC
LSC, my
number
lord.
278 of link 1990.
Yes, my lord. This is transferred, my lord. Left side it is written, my lord. Transferred by assistant, my lord. Assistant settlement officer to the
Where
petitioner.
transferred?
It was, my lord, 2/3/2005, my lord.
Huh?
2/3/2005.
Where are you getting the date?
Left side, my lord. Left side, my lord. Yes, transferred to. And their statement in 1996 that they are dispossessed, my lord, in the writ petition. And so for petition number 2, my lord, it was 2003, my lord, transferred, and petition number 5, my lord, 2003, my lord, or my lord, respondent. Petition number 3, 2003, petition 2, my lord,
No,
2003.
it's okay.
Yes.
These are various aspects which will be looked into by the civil court.
Yes.
But the question is, why should we,
Yes.
the writ court should indulge into this?
And no point of view dispossess
No,
them.
we do one thing. We admit this petition, state. At the end of the day, Mr. Counsel, again the problem which will arise is, this will be dismissed. His appeal will be allowed. And at the end of the day, you will have to file a suit. And when you file a suit out there, then you are going to another, this is only going to delay it. Instead of that, you should have filed a suit. Limitation is 3 years.
And my lord, this lordship made produce their affidavit of state government, my lord. Affidavit of state government, my lord. State government affidavit, my lord, page 47, my lord. My lord, here paragraph 4 stated that with regards to statement made in paragraph 3, petition, I say that while being occupied by the force, the petitioner acquired LSC in the year 1994. Therefore, it cannot be said that the occupation is not forceful in nature. So from 1966, the army was there, my lord. And the whatever my paragraph 44 is so those petitioner, my lord, their original their name was there, my lord. They filed a petition. My learned friend client never filed any petition on the basis of the earlier original owner, my lord. They now all these things they are claiming, my lord. And so far paragraph 7 is concerned. It is paragraph 10 of the writ petition. I said at the time of acquiring LSC, petitioner did not claim any rental compensation. It is stated in affidavit by the state government, my lord. It is never known that their lands were located within the army area. It is paragraph 10, and thereafter, my lord,
My
paragraph
lord,
9.
if I may,
After
let the appeal be admitted and I'll leave it to your
26 years, my
lordships.
lord.
Huh?
Let the appeal be admitted in the meantime, then I'll leave it to your lordships.
Mr. S.K. Medhi, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondents. Private respondent numbers.
4, 5, 6.
4, 5, and 6. And so appears on behalf of the respondent numbers 1, 2, and 3. The instant appeal is directed against the impugned judgment and order dated 15/2/2023, passed in WPC number 170/2019. Upon hearing the learned counsel appearing on behalf of the appellants as well as the counsels appearing on behalf of the respondents, we are of the opinion that this is a fit case for admission of the appeal. Accordingly, the writ appeal stands admitted. The registry is to tag along the is directed to tag the writ procedure, the records of WPC number 170/2019, taking into account that all the respondents are duly represented. The appeal is fixed for hearing. Is fixed for hearing on 13th of November
My lord,
2024.
November, my lord, not possible. December, my lord, 9th of December.
Huh?
December, my lord, 9th of December.
What?
9th of December, my lord.
9th of? 9th of?
December, my lord.
9th of December, why? It's a beautiful day. The sun is going to come up.
No, my lord.
What?
I'm coming.
Absolutely no. 13th of November, you are always there in the year. 13th of November 2024. It is also submitted by the councils appearing on behalf of the parties that have received the copies of the writ appeals. Extra copies of the writ appeals be served upon the respective councils by the appellant during the course of the day.
My lord, instead of my
Obliged,
lord, 13, 15 of November.
What?
15 of November.
For you, the division bench will sit.
No, but
15 is a holiday, my lord.
We'll have it on 13th of November.
yes.
No 15th.
And my lord, item 4, my lord.
Wait. I is there with the council. This is an application for stay of the impugned judgment and order dated 15/2/2023, passed in WPC number 170/2019. We have perused the impugned judgment and order. We have also heard the learned counsels appearing on behalf of the applicants as well as the opposite parties. We have also taken note of that the accompanying writ appeal has already been admitted. Accordingly, taking into account that the appellants have been able to make out a case for stay, we stay the impugned judgment and order dated 15/2/2023, passed in WPC number 170/2019 till the disposal of the writ appeal. I stands disposed.
Deeply obliged.
My lord, item now 4, my lord, similar, my lord, arising out of this judgment of this, my lord. It is reflected in paragraph.
Item number 4 lists this matter again on 13th of December, November 2020.
Along with this, along with it.
We'll see. You make that same submission before.
Yes,
the next.
Earlier.
Item number 3.
My lord, this case was heard on 24/10 and Your Lordship allow the state respondents and the Union of India to make their additional submission. My Lord, this is a case regarding that award passed under the old act, which Your Lordship had made an observation that the award should have been lapsed.
Oh, this one.
Yes, my Lord.
They have not acquired, no? They have
They
acquired.
have not acquired as per law.
Now, tell me one thing.
My Lord.
That's where so many petitioners come together. Case here is issue a written in the matter of a acquisition of a month so and so, wherein the respondents appeal to pay payment of compensation to the petitioner in respect to the award dated demand. The petition is also for payment of solatium and interest as per the so and so. So you want the payment of amount. That is why you filed the writ
Yes,
petition.
my Lord. That is the awarded amount of the district
Then what
collector.
happened?
Now,
What did the single judge do?
the single judge, the single judge of the opinion that there was some disputed question of facts. And since the respondent has also raised objection with regard to the authenticity of the award, it relegated us to the civil court.
Has this award been approved?
It was approved by the government. It was approved by the state government
Then,
on 31/7/2018,
then,
which was not challenged by way of a writ petition or by way of any reference. Now, this is the word which we have sought a prayer for Mandamas, that we have to give us this award, which was arrived by the district collector. Now, there is a letter, my Lord.
there is also the award does not include the solatium and interest.
It includes the solatium and interest also, my Lord.
It is because why does at paragraph number 2 of the impugned judgment says so? See, fail to make payment of the compensation amounting to rupees so and so to the petitioner in respect of the award number demand. The writ petition is also for payment of solatium and interest as per the right to fair compensation award and interest as per section 80. Let's see your writ petition.
The writ petition is at page 208 to 407.
Yes, admit the petition, call for the records, issue a ruling, so called by the petition. Why issue? Notification issued in 2012.
2012,
Section
section 4.
4, na?
Yes, page 303,
Then section 6 is when?
2013. 8/4/2013.
Then award passed in 2018.
2018.
So that day I said that
Yes,
this
yes.
award is bad,
Yes,
taking
Malak.
into account that, yeah.
11A of the LA Act. 2 years has lapsed,
11A.
my Lord.
Then, under such circumstances, this award has not been challenged by anybody.
Not challenge.
Now you are asking this payment. They are giving you solatium at 30%.
Yes, my lord.
Interest from so-and-so to so-and-so 10%.
Under the old act.
Yes, why is the government not making payment? Why you are not making payment?
My lord, the construction of relating to the present cases already done in the year 2007. However, at that time, the state government or agency do not strictly apply the Land Acquisition Act. However, everything has been done and assessment has been
Then
made.
why have you not challenged the award?
My lord,
You are a person interested, and why haven't you challenged this award? Why haven't you said that the state government has committed fraud upon you? But how can you take somebody's land? Return the land. You are going to return the land? Give an undertaking, you are going to return the land, don't pay.
my lord, we had already made
You
a
cannot
payment.
take the land of somebody, or the state cannot give you the lands of somebody when these people are the owners.
My lord, at that time, we are ready to make a payment as per land acquisition. However, our agency, there is a lapse from the side of the state agency.
Lapse of?
That is why, my lord, the Union of India cannot suffer due to the failure on the part of the state, my lord. We had already make a payment 40 lakhs point something for this construction of road. However, later on, after a lapse of 13 years, the present Land Acquisition Act has been, the present award, number 1 of 2018, has been passed by the state government.
Then how could you take the land of somebody? But because of the fault between both of you,
My lord, at that
can
time,
can the petitioner suffer?
my lord, at that time, none of the petitioner, none of the landowner do not have a land LSC. Their land pass is VC pass, WRC pass, so and so only.
So these land belong to whom?
Belong to the petitioner who have a land pass at that time, my lord.
So they have the land passes.
Now they have LSC. That is why in the earlier court order, my lord, direction has been
The LSCs are there. These people, this is the
during the year
determination.
2007, no landowner have been a LSC, my lord. Their land pass is VC pass, WRC pass, so and so only, my lord. That is why the present award, number 1 of 2018, seems to
You
be
cannot
fake,
come
my
up
lord.
with all these things. Unless none of the interested have raised any objection to the measurement of the respective health, I hold that to be the true area of the land. Market value of the land has been determined after taking various factors like location area. Residence is so and so, 50 rupees per square meter. One award won, and therefore considering all the factors, market value of the so and so. When was this award? This is the land. Approval of the award number 1, construction of the year, approval given in the year 31st of July. Then this is the letters being written to you. You have not challenged it, and now you cannot come up with all these things. Of the respond number 2. Who is respond number 2? Yes. How can you make payment to anybody?
My lord, as per assessment made by the
No,
state.
tell me, is it permissible for those persons to go up, you being the union or whoever it is, go there and unless you have a sale deed? How can the land vest upon you unless there is an award? The land can vest upon you only in terms with there being a conveyance or by way of an award.
My lord, everything has been done by the state respondent. Then we just make a
We are
payment, my
not
lord.
concerned. You have to pay or give up the
Then
land.
the payment has been countersigned by the DC also. However, later on, the DC denied it. That is why the land single judge opined that that should be.
Why haven't
there
you
is-
challenged the award? Tell me. You have not challenged the award. You should have challenged the award. come up
My
with
lord,
all
we
these
are
things.
not part of the award, my lord.
What?
Union of India is not part of the award.
Union of India is very much there. You should have challenged the award. If you don't challenge the award, matter against.
Because in the same stretch of road, my lord, we had already made a payment.
This can't
Now, after a
happen.
lapse of 13 years, how can they issue a award number 1 of 2018? Then in that award,
Then why are you not challenging the award? You have a right to challenge the award. Why haven't you challenged the award? You cannot object to it till an award remains.
my lord,
You are a person interested
in
terms of
this
Section
award, my
3B.
lord, the NPCC is participated in this award. However, at the relevant time in the year 2007, the BRTF is the constructing agency. However, in this award, the BSF, through his each agency, NPCC, then the NPCC participated in this award, my lord. That is different issue, my lord. Now, the concern of BSF and each agency NPCC, as on date, my lord, no formal notice has been issued the NPCC and MADC.
And government, what do you have to say?
Lordship, as per the affidavit in the position in the before the single judge, the
You have given an approval to the award.
yes, we have
Once
already
you have
approved
given
the award.
approval to the award has become final.
Yes,
So why does the single judge have to say that it is not understandable how this there are certain disputes? It is after all there's a
Yes.
finality attached to the
Yes.
award. Nobody is challenging the
no,
award.
yes, no,
Then-
no award is yes,
then
no
why
one
you
has challenged
are-
the award. Yes,
Why the authority is concerned has not to pay. If we are there are two options available to the state the requiring authority. They could have very well challenged it. They have not
Yes.
challenged it.
yes,
What you have done. If you go as per this award, the amount is less. If we set aside, if we take the issue as regard 11A, the entire thing goes for a 6, then they have to go for a fresh acquisition. And fresh acquisition, the amount will go up phenomenally because now the 2013 Act comes into play. As of now, although there was a Mizoram in Mizoram,
yes,
you initially did not adopt the 2013 Act.
yes,
You came up with a 2015 ordinance, which was followed by a 2016 Act.
2016.
Now, this 2016 Act has been set aside,
Yes,
struck down.
yes,
And after it is being struck down, I think the matter is pending in the
yes,
Supreme
in the
Court.
principal bench.
But then, under such circumstances, Mizoram is now, in view of a notification issued in the year
Yes, yes, yes.
2019,
Yes, yes.
you are now following the 2018 Act, 13 Act,
Yes, yes,
isn't it?
yes.
You are in more trouble.
CNPC sa sektoran nila. NPCC kan. NPCC kan sektoran. Then pass कर this year second 2022
Give us the land acquisition.
Okay, hearing completed, judgment reserved.
My lord,
Much
if I
obliged.
may permit it, one line.
No, nothing doing.
Uh,
It
The
is
prayer,
actually there to say. No, you cannot come up with all this. Better, I think you should go to Supreme Court. The law is very clear. You are to pay. You have taken the land, you should have challenged it. You
My
want
lord,
to- If you say that there is a fraud being committed by the state, do it. There are various judgments to the effect.
my
You have
lord,
not done it.
regarding the applicability of 2013 Act, I have filed my affidavit. Then I
No,
stated.
no, we are not concerned about the 2013 Act. We won't bring the
Yes,
2013
Yes,
Act.
my lord, my lord.
The award will remain as it is.
Okay.
Okay?
Yes.
We are not going to bring in the 2013 Act because there, if he wants to bring 2013 Act, it was the requirement of him to make a reference.
Obliged.
So we are not going to go into that question. The fact that there is an award existing, you are liable.
Okay.
Because if you go into the 2013 Act, there are a lot of other complications,
Okay.
which we would not like to enter.
Obliged.
For motion, item number 1.
May it please your lordship. My lord, this is a contempt petition that arises out of WPC 194 of 2016 that was disposed by judgment and order dated 21/7 of 2023.
Where is the judgment?
The
Where is the
judgment,
portion? What is the directions?
my lord, the
On due
judgment,
consideration of the matter,
judgment and order
I
is
find
at
merit
page
in the
49.
petition according to Deputy Commissioner Director will calculate the solation and interest payable to the petitioner under remand and interest for delayed payment. So thereafter the respondent shall forward the same to the remand. Upon receipt of the sum. Now you have informed them.
My lord, notice has to be issued to
Has
respondent
given
number.
it to 54 crores.
Yes, my lord.
Now they have not deposited that.
Yes.
Huh? Now whom have you made party?
The parties,
Why you are making the secretary to the government of Mizoram a party?
my lord, they were made a party in the WPC 194 of 2016.
No, understood, but the direction was given to what? To the deputy commissioner to make calculation?
To make calculation,
And then
and
for
to-
the other respondents to make the payment?
yes, my lord.
And has the payment been made? No,
Not yet, not
not
till
made.
date.
So why are you making the secretary to government of Mizoram, Home Department a party? Why you are making the deputy commissioner a party? The deputy commissioner has done his job,
Yes,
has he
my
not?
lord.
And how are you making the number 5 a party?
Respondent number 5, my lord, he's the joint secretary. We couldn't locate.
A contempt is only
Yes, my
against the
lord, I
person.
understand. However, when he was made a party in the WPC, and as we cannot locate him, respondent number 4, the additional secretary, NE2 of Government of India, Ministry of Home Affairs, it seems he handles this matter.
Anyways, you do one thing.
Yes, my
Let
lord.
it come up next week. Because for me, I think you should make the joint secretary to the government of India as well as the general manager is by name parties. You have made number 6.
Yes, my lord.
You have rightly done so. But what about number 5?
Number 5, my lord, as I've said, the respondent number 4,
Why you are making the additional secretary any government of India, Ministry of Home Affairs a party?
because the joint secretary, who is respondent number 5, we could not
But
locate.
he does not know. This person, Mr. Piyush Goyal,
Yes, my lord.
has he been informed or intimated by anybody that you have to pay? How will he know? We have it next week. Nah.
All right, yes, my lord.
But I think you can very well go to the website of the Home Department of the Government of India and find out who are the, and in that particular thing, about us will come in.
Yes, my lord.
About us, you'll find out who are the persons who are there as the joint secretary. Get the name properly and then put it out there. Don't you think so?
Yes,
Otherwise, you
true, my
cannot
lord.
have it against the joint secretary. It has to be by name.
Hmm.
What to do next week?
Yes, my lord.
The request of the learned counsel for the petition of the matter stands
Obliged.
listed next week.
Item number 2.
May I please, Your Honor?
Yes.
This is the subsequent writ petition
Then earlier writ petition 79 of 2024 was disposed on 30/9/2024, Lordship, due to infructuous. As the suspension order clearly states that this is the suspension order for the period of 3 months. During the pendency of the WPC 79, the entire period was already exhausted. So that is
Which one? What suspension? Which order you are challenging?
now I'm
19/6,
challenging the order
2024. Where is that
110/2024, Lordship.
Huh?
110 dated 110.
Where is that order? Page?
Page number 48, Annexure 9, Lordship. The previous suspension order was simply extended without any notice. As we know that, Lordship, this audi alteram partem, no one should be condemned unheard. So we were not given any opportunity to be heard, and no notice was issued to us. And simply the
Show me the 19/6 order. Yes, whereas the complaint has been lodged against the executive body of aided by so-and-so on various maladministration, where several maladministration and municipal offences are found during this prohibition which is committed by the exercise of the powers under so-and-so.
Annexure 7, that is page 43, that is the 19/6 order.
Now this suspension is done under what provision?
There is no provisions in the
No, they have mentioned it.
they have mentioned, that is, Lordship, that is they can interfere.
Show me the act. Where is that act? Where can I find that act? Who is appearing for this Chakma Autonomous District Council?
Page 9, that is, Lordship, the Chakma Autonomous District
You are a
Council.
village council, na?
Yes. Chakma Autonomous District Council, Village Council Act 2003, Lordship, that is page 9, paragraph 14, Lordship. The executive committee shall have the right to interfere in the village administration in case of mismanagement of village council fund or maladministrations of the village council. That's all, Lordship. That what my understanding is, that interfere by the higher authority does not mean
Show
that.
me the this Chakma Autonomous District Council. District Council is where? District Council means the software. What is the power of the District Council?
Page 9, Lordship, this they have a power to interfere with the village council administration.
Any member of a village council who, due to seriousness or failure, shall be declared.
Page 9, Lordship, that is Act 2003, page 9.
Now, what is the power of the District Council? Where will we find that the power of the District Council? Here, I think so. duties and functions of the village council. The power of the district council?
Constitution of Village Council, that is, Lordship, Chapter 2. There shall be a village council in each village within the jurisdiction of the Chakma Autonomous District Council.
Provisions of this area described in this behalf by the executive committee, the village council may exercise all or any of the following functions. Okay, 9(1). So there is no power.
They have no power for suspension, Lordship. There is no provisions at all. In fact, Subpara 1, Section 26, they can dissolve after giving public notifications and after being heard.
Which one? Which power?
There is Section
The executive committee by public notification over order the dissolution of village if it is in the opinion that the villager is too inefficient or is not able to carry out or is acting in manners prejudicial to the interest of the state or for any other reason. Who is the executive committee? Let us see. Committee means the executive of the Chakma District Council. Okay. May appoint any person to assume the charge of it or also enact in a village council or during the period of intervening dissolution of the village council. The village council has been dissolved. So you say that the power is there of the executive committee to dissolve
yes,
if it is inefficient, but there is no power to suspend.
suspension. Yes.
But what do you say about Section 21 of the General Clauses Act? Give me the General Clauses Act.
Lordship, this is Autonomous District Council constituted under 6th schedule to the Constitution of India. So,
Understood. But I am saying the General Clauses Act stipulates that the power to appoint includes the power to remove. The power to remove includes the power to suspend. The power to suspend includes the power to anything.
suspension, the word suspension is not reflected at all. It is
Understood.
dissolve. Dissolution is there. Yes, they have the power
Does the
to dissolve.
Mizoram have a General Clauses Act? State of Mizoram? Yes, madam. You are appearing for whom?
I'm appearing on behalf of the respondent number 1, my lord.
Chakma?
No, my lord.
State-
You are
The
a
state
government?
respondents, yes, my lord.
Okay, now tell me whether the Mizoram has a General Clauses Act. I think Mizoram must have a General Clauses Act.
The General Clauses Act 1897 is there, my lord.
Power to issue, to include, power to add, power to amend, vary, receive notification. By initiating, power is issued. Yeah. Yes. 16. Power to appoint to include power to suspend or dismiss. Where any central act or regulation or power is made to make an appointment is conferred, then unless a different intention appears, the authority having, for the time being, power to make appointment shall have the power to suspend or dismiss any person appointed, whether by itself or by any other authority in exercise of that power.
Lordship, this analogous case WPC 70 of 2022, this court has elaborately observed and make an order regarding this suspension of the village council, Lordship. That is, relevant paragraph is para 11, Lordship. The same analogous case, that is regarding the village council, administration of the village council, suspension of the village council.
It is a different thing. That is another aspect. Without following the natural justice, if it is being done, it is another aspect which can be very well taken note of. But the power is not there is another aspect. There are two different aspects. Ne?
Yes, sir. Lordship, in this case, we were not given any chance of hearing. That's I have
Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of
The state respondent
respondent
number
number
one.
1. Who appears for 2?
No one, my lord.
Okay. Respondent number 1. Was to issue notice making it returnable on. We are not passing a stay.
Lordship, if stay order is not part, it is only for 3 months, Lordship. During the pendency, again, the matter will be.
But how can we know whether they have given you the opportunity of hearing or not? People issue a short notice. Let them come, take steps against them by way of dusty.
Yes.
I think that is a better one. I put this thing. Okay.
And through the liaison officer, Chakma Autonomous District
Yes,
Council.
issue notice making it returnable on 8th of November. Can you serve it?
Yes.
8th of November 2024. Full stop. As Ms. So-and-so appears on behalf of the respondent number 1, extra copy of the petition be served upon her during the course of the day. As regards the respondent number 2 to 6, the petitioner is directed to take steps. Petitioners are directed to take steps by way of registered post with AD. Full stop. In addition to that, the petitioner is also given the liberty, is also directed to effect service upon the respondent number 2 to 6 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date.
Lordship, if through the liaison officers of the Chakma Autonomous District. Otherwise, their headquarters is Chongte. Now the condition of road is very deteriorated, and it is.
No, these
it
people
takes
are
long
there.
time.
Where is Kamla Nagar?
Kamlanagar is southern part of Mizoram. Road condition is very, very deteriorated.
So therefore, we are fixing it, or let us fix it on 12th of November.
No, 8 will be, Dasti will try to serve it within 8.
But then also somebody has to carry it from here
Yes.
and serve it out there. These people are there in one locality.
Yes, through liaison officer of the
You
Chakma
give it to number 2, the 2 and 3. What about the others? Why you are making the others a party 4, 5, 6?
They are the complainant, Lordship.
Then they have no business out there. You are concerned with 2 and 3. Otherwise, the service, if it is not done, it becomes very difficult. We do about. Can you serve upon the 4, 5, and 6 by way of Dasti?
4, 5, say it will be little bit.
They are in your village only.
No.
They are, oh yes, Asora 3. Resident of Asora 3. You are,
Ajasora is far different from the this
but you
Kamlan
are the
number.
village council of the Asora 3. Are you not? You are the village council. Why can't you serve?
That is that is very far distant area from Kamlan. Okay, Lordship.
You ask your petitioner to serve it.
Yes, yes,
Ask this person to come over.
yes.
Mobile phone. Stay enrooted and file an affidavit of service on or before the next day. The case of the petitioners herein is that the petitioners are members,
Elected members.
are elected members of Ajasora
Village Council.
Des 3, Roman 3 Village Council, and the executive member of the Chakma and by the notification dated 19/6/2024, the executive committee through its executive member of the Chakma Autonomous District Council, Kamlanagar, had suspended the executive body of Ajasora Roman 3 Village Council. Full stop. Thereupon, for a period of 3 months,
Yes.
thereupon, again by another notification dated 1/10/2024, the suspension of the village council, of the executive body of the said village council, was extended for another 3 months. Full stop. It is also relevant to take note of that a perusal of the notifications dated 19/6/2024 and 1/10/2024 reveals that instead of the petitioner, instead of the respondent number 2 and 3 have also appointed the respondent number 5 as the caretaker to look after the functions of the village council, president of Ajasora 3 Village Council till further notifications. Full stop. The case of the petitioner herein is that in terms with section 26 of the Chakma Autonomous District Council Act 2003, the power conferred upon the executive committee of the Chakma Autonomous District Council is only to dissolve. However, there is no power to suspend. In addition to that, the learned counsel appearing on behalf of the petitioner further submits that the manner in which the suspension has been done and have been further extended have been done in violation of the principles of natural justice, as the petitioners, who are elected members of the village council in question, have been removed, have been not allowed to function, which is not the mandate of the Chakma Autonomous District Council Act 2003. The learned counsel appearing on behalf of the petitioner submits that this is a fit case for grant of an interim direction pending notice being issued. Full stop. This court, having heard the learned counsels appearing on behalf of the petitioner as well as the respondent number 1, is of the opinion that without providing an opportunity to the respondent number 2 and 3 to submit its explanation as to whether the principles of natural justice have been followed prior to issuance of the impugned orders impugn notifications dated 19/6/2024 and 1/10/2024, it would not be in the interest of justice. Accordingly, this court fixes this matter on on which date the interim order so prayed for by the petitioners would be duly considered. Full stop. The respondents, more particularly the respondent number 2 and 3, are directed to place before this court their stand by filing their affidavit as to whether the respondent number 2 and 3 has the power to suspend the executive body of the village council, and further as to whether the petitioners have been provided any opportunity or any inquiry was conducted prior to issuance of the notifications dated 19/6/2024, which was subsequently extended on 1/10/2024.
Lordship, if the date is fixed on 8, that would, otherwise the time is almost 1 month is already against going to
Don't
be
worry,
expired.
your petitioner will come, na? Give it to him, this order and the copies, and then let him serve it. I made it very clear, concise. In fact, with this, you can get your judgment early. The matter can be disposed of as early as possible. That is why I've asked him these pointed queries. The answer is yes. No. In the principal seat, if we do it like this, you get an answer immediately. But the question is, it is a bit difficult to say that they don't have the power to suspend in view of the General Clauses Act. However, principles of natural justice has to be followed. Whether there was an inquiry or not, it is not known. So let us see.
Obliged, Lordship.
Item number 3 and 4.
This is for orders. Yes, what is these?
My lord, in this case, on the last occasion, your lordship had directed the respondents to obtain instruction as to what possession has been already taken in respect of the land of the petitioners.
It is a matter of 2019 pending.
Yes, my lord. In fact, my lord, there was an award, a supplementary award made on 2016, which was, however, cancelled, and we are challenging the cancellation of the award. And during pendency of the award, with the leave of the court, another award was recently made, which is not yet finalized.
To file application for impeachment. Why is the contempt petition here?
That is already closed on the last occasion, my lord, last week. Your lordship had already closed the.
Yes, what does the respondent have to say?
My lord, now in the award which was recently made, the.
You have not filed, have everybody filed their affidavits?
Yes, my lord.
Filed.
For the state,
Yes,
we
madam.
have filed.
When did you file the affidavit?
Long time back.
Then somebody has not filed. 2 weeks time granted to the respondent number 8 to file the affidavit in
The central
WPC
government
number
has not
8
filed.
for filing affidavit in WPC 90, and similarly petitioner are granted 2 weeks time to file reply. Everything done.
We are impeded to provide for the latest 311 of 2022. If I take more time for filing my affidavit. But they just trying to state that regarding the 138 genuine landowner, they are still awaited the revised cost estimate from safety for making payment.
This is acquisition made under what provision?
The present one, recent one, which is under process, is made under 2013 Act.
You are asking for payment of compensation as per the Land Acquisition Act 1894?
My lord, as I have submitted earlier on the last occasion, my lord, this writ petition has been filed due to cancellation of the supplementary award, which was already pronounced and approved. And during pendency of the instant petition, my lord, this court had direct to maintain status quo. And in spite of that, my lord, the state respondents have sought for leave to process with 138 genuine undisputed landowners to make payment.
Oh, that's some
Yes,
other
my lord.
matter. Did I hear this? No, na? This 138 about that
138,
thing,
yes, my lord.
somewhere I heard it.
Your lordship has
Last
disposed
week,
of
my
the
lord.
contempt petition last
Ah,
week.
that contempt petition. na?
Yes,
My
my
lord.
lord.
And
Okay.
in the present
Oh, I
case,
closed the contempt petition.
yes, my lord,
Yes, yes.
Contempt was already
138,
closed.
yes.
138.
Now then,
now this for 138 of them, with the leave of the court, the state respondents, the DC of the concerned district, had prepared fresh award. Although approval was already granted, the same is not yet finalized, my lord. So
now these are the petitioner 138 who are there.
yes, my lord, they came in, they filed this petition.
Have they passed the award? They have not passed the award.
Award-
2000 if I remember, they were awaiting the disposal of these writ petitions of 90.
90.
Unless writ petition of 90 is not disposed of, they are not in a position to
Yes, my
go
lord.
ahead with the
So
138.
if the instant petition may be disposed of, that in the respondents' concern to finalize the award which was already made, and in view of the award which was prepared under the Act of 2013, my lord, the Section 80 delay interest after taking possession was already included. That implies that possession was already taken undisputedly on account of construction of the said road over the land of the petitioners.
Now these 138 who have been given, now this is 138, na?
They were not
Contempt
yet.
1 is closed. Contempt 1 is closed.
Yes, madam, contempt is
And then
closed.
1 is closed, that's prayed for. That is, I closed it. Yeah, heard so and so the instant contempt has been filed alleging willful and, oh, this order, why is it here? Anyways, contempt proceedings is dropped. Now what order has been passed in this case? Why the matter is here?
My lord, on the last occasion, your lordship had directed the respondents' counsel to obtain instruction as to when was the possession taken.
Is that order? There is no order other. Oh yes, list this matter again on him on which the state as well as the union shall apply whether the possession of the land belonging to the claimants in respect to the supplementary were taken by the authorities, and if so, when? Yes.
My lord, with regard to that, the construction of the roads is complete in June 2023. We have completed.
Understood. Whether the possession of the lands belonging to those claimants in respect to the supplementary award was taken?
My lord,
That
with-
is what I am asking. The claimants are there in mentioned out there in the supplementary award number 1/2016. If you have taken the possession and there is an award, it has attained finality, the land rests upon the state. Why they would not be entitled to payment of the compensation?
My lord, with regard to the supplementary award, which was already cancelled, my lord, there is no, according to the state, there is no
Supplementary
state
award
approval.
1/2016 has been cancelled.
Yes, cancelled.
Very well. At that point of time, supplementary award number 1 pertaining to 620 or people,
303.
303.
something, of which 138 has already, you have found these to be the actual claimants,
Genuine claimants.
genuine claimants. And thereupon, now, therefore, I am asking you whether any land belonging to those claimants of supplementary award of maybe it has been cancelled, but there are a list of persons who are there.
Yes.
Whether then their lands were taken.
Yes, my lord. According to the ACB investigation, they are the genuine landowners. And construction is already completed. The lands are
Understood,
taken.
but whether their lands have been taken, if their lands have been taken, then how could you take their lands without following the due process?
My lord, the lands are taken, and I have, my lord will see that this, the lands have 3 holdings. There are 3 holdings in the land. One is of private land where we have already paid, and the other is a forest land, and the other is a degraded June land, which is a deemed forest. Now, for that, my lord, we have written to the Ministry of Environment, Forest and Climate Change Department, but we have not received any clearance for that because it's a degraded June land.
So those persons whose lands, now tell me, how do you take care of a situation with the 2006 forest protection rights have come into being? How do you take care of a situation?
My lord, if your lordship may kindly see the recent award which was made, draft award.
What?
All this, in respect of these 138 claimants, they have recently made the award with the leave of this honorable court. This is draft award number 1 of 2022. And if your lordship may kindly come to the draft award, second page, forest land. Forest land. Under the heading of forest land on page 2, second page. Have you got it, my lord? The meeting already held at the portion of forest area which was already identified. They are willing to make payment after they completed the NPV, they calculate the net present value. And no one is objecting payment of compensation to private landholders.
Now, has this been approved?
My lord, in the piece of letter which I served, I placed before your lordship, letter dated 7 July 2022. This is the approval.
Here there was an increase of solatium at 100%. Total amount. Solatium is to be calculated on what? Market value of the land only.
100% of the land value.
Then why it has been calculated more?
It was miscalculated at the rate of 200% before this. And this is the correct calculation, the present award which I placed before your lordship.
No, the total amount will be 13 lakhs 79,000 plus 5 lakhs plus 27 lakhs. So it comes to around 14 lakhs 12,000. So on that another 14 lakhs 20. Then this comes to 15 lakhs. Approval where?
On the other piece of paper, my lord.
Approval has not been government approval for original with respect to the money management. The parent company. For 60 lakhs it has been approved.
60, yes, my lord.
60 lakhs or
64.
60 crores?
60 crores.
Have been approved.
Yes, my lord.
Then why you are not filing a affidavit and bringing on record this aspect? Huh?
The state that they have already filed this.
Tomorrow I allowed your petition out here. These people may say that nothing was brought to the notice, we did not know anything, more particularly, Madam there will say.
My lord, it's available in the affidavit of the state.
Have you brought on record this?
They have, yes, my lord.
It's there on
My
affidavit?
lord. The affidavit filed by respondent number 5, additional affidavit.
No, as regards the approval.
Yes, my lord.
Yes, government, who is to pay?
My lord, the state, the central has to pay.
Why you are not paying?
My lord, for making payment and for making sanction, we are awaiting revised cost estimate from the
That
state
has already
PWD.
been given.
Not
Why
yet
you are not
given.
paying?
We are not yet received from the state PWD.
No, you can't do that. Return the land to them. Can't happen like this. Absolutely encourages.
Because, my lord, with regards to 138 genuine landowner,
In Mizoram, you have 90% of land compensation matters only. Till now, I have already done 4. Now you want the 60 crores to be paid to you
Yes, my lord.
in view of the draft here.
Yes, my lord.
It has been finalized.
Yes, my lord.
Approval has been granted then.
Yes, my lord.
Where is that an affidavit we have brought in?
Affidavit,
so you have to affidavit in our file.
the, 24/4/2024, filed on 24/4.
No, there, that affidavit, if I remember, 24th of year, that affidavit, if I remember, they say something else. That we have not finalized in view of the pendency of the writ petition.
No,
Something
my lord,
like
it's
that.
written here, the draft of what so and so 2021 in respect of 138 genuine landowners had been approved by land revenue
Where is that affidavit?
filed on 24/4.
24 April, my lord.
That
24.
I've seen it, where is it now? But what will happen to the other people? Say, I can't read it from here. May. 14 May affidavit.
No, my lord, 24th April.
No, not there. Well, let this matter come up next week. I'm not getting that affidavit. I have it next week.
Let Madam also file her affidavit, madam.
Since the State
CPC.
Union of India, they are yet to file. If, as
Have
the
you
matter,
brought on record these documents, all these documents, the 5 documents?
I may
which
also
you
be
are
granted
giving?
liberty, I may also be granted liberty to place that on record.
You file it by way of an affidavit.
Yes, my lord.
Once you file it on affidavit that there is a final award being passed out there approved, then this court will be bound.
Yes, my lord.
The learned counsel appearing on behalf of the petitioners has placed before this court certain documents which shows that the supplement, that an award number 1/2022 amounting to rupees 60 lakhs 81,095,000 60 crores 81 lakhs 95,531 have already been approved by the government. On 14th of have already been approved by the government
7 July,
on 14/7/2022.
7 July, my lord.
On 7/7/2022. Full stop. The learned counsel submits that he may be permitted to bring on record these documents as the same would have a vital bearing on the outcome of the writ petitions. Full stop. Taking into account the above, the instant the liberty is granted to the petitioner to bring on record the same by filing the affidavit. This matter again on 11th of November. You can file your affidavit by then?
Yes, my lord.
My lord, let it come up on 12th. 11th, I have some
Okay, on 12th of November.
engagement.
Sure.
Much obliged.
Obliged.
Item number 5.
This is come for what? Why has this matter come? Why has the matter come today? For orders? Now, have you served effective service upon all the respondents?
We have served through the liaison officer, Chakma Automara District Council, and we have also filed
Oh,
affidavit.
same.
However, Lordship, this...
Here also suspension.
Yes, the same suspension.
Anybody appearing for Chakma?
Your Lordship? No, Your Lordship, they don't have a council.
Huh?
They do not have a council, Your Lordship.
You have not served till now.
We have served to the
you
respective
have served-
party, but their councils, they have not the standing council at present. Chakma Automara District Council, they don't have.
Oh.
So this is the one of the advantage they are taking, Lordship, as the suspension period is only for 3 months. So by doing this and
But
that,
how are you going to serve then? Tell me.
earlier we have served, Lordship, through the Chakma liaison officer, Chakma Automara District Council, and affidavit also we have already filed. But after that, we were again directed to serve this routing this registry, Lordship. That it can be considered, Lordship, as a deemed service.
But what to do? It has been received by whom?
Received by this liaison officer, Chakma Automara District Council, Lordship.
It is there. The Chakma Autonomous Council is there.
Yes.
But this has been held to be not proper.
The court say that, Lordship, this is
What to
not
do?
proper. So another step we have taken that through this registry post,
I
Lordship.
would have accepted this. Huh? But here I can't touch anything.
And here they are not appointing any standing council on behalf of the Chakma Automara District Council. That is why we are facing a lot of problems, Lordship. Again, another 3 months is going to be expired, Lordship, before the disposal of the case and without any interim order, Lordship. So this way they are playing this their political vendetta, this district council, and the smallest unit of the democracy is
We
suppressing,
fixed
Lordship.
this on 8. 8, along with the other matter.
Yes, Lordship.
From a perusal of the office note, it reveals that the service upon the respond number 1 to 8 is not complete. This matter again on 8th of November 2024.